everyone, welcome to Topic of the Day. In today's video, we are going to discuss about the Criminal Procedure Identification Act 2022. Now recently this has come up in news as the Ministry of Home Affairs notified the Criminal Procedure Identification Act 2022. So let us discuss a bit more about the act. The Criminal Procedure Identification Act provides legal sanction to law enforcement agencies for taking measurements of convicts and other persons for the purposes of identification and investigation of criminal matters. Now, it defines measurements to include finger impressions, palm print and footprint impressions, photographs, iris and retina scan, physical, biological samples and their analysis, etc. The National Crime Records Bureau, that is the NCRB, will be central agency to maintain the records. It will share the data with law enforcement agencies, and the data collected will be retained in digital or electronic form for 75 years. So what was the need to replace this act? Over the years, the need to amend or update the Identification of Prisoners Act 1920 has been voiced several times. With advancements in forensics, there was a need to recognize more kinds of measurements that can be used by the law enforcement agencies for investigation. So as you can see, the Criminal Procedure Identification Bill empowers police to collect fingerprints, palm prints and footprints, etc. Further on, in the year 1980, the 87th report of Law Commission of India undertook a review of this legislation and recommended several amendments. This was done in the backdrop of State of UP versus Ram Babu Mishra case, where the Supreme Court had highlighted the need for amending this law. So let us discuss some of the concerns related to it. Since the Identification of Prisoners Act 1920 was a colonial legislation, its duplication in Criminal Procedure Act 2022, that is a post-independence legislation, has raised some concerns related to the protection of fundamental rights. The legislation comes in the backdrop of the right to privacy being recognized as a fundamental right as per the Puttaswamy judgment. Now, this law was not submitted for public consultation or referred to the parliamentary standing committees as was done for DNA Technology Regulation Bill of 2019. There were fears that the law will give unbridled powers to the state and executive machinery and may even lead to narco analysis and brain mapping of the citizens. Critics also argued that the law failed to put in place adequate restrictions on storage, sharing or usage of the collected data of the accused. Now, one another worry expressed by the experts is that such collection can also result in mass surveillance, with the database under this law being combined with other databases such as those of the Crime and Criminal Tracking Network and systems. Lastly, the concerns are being raised that the present law violates the right against self-incrimination enshrined in Article 20, Clause 3 of the Constitution of India. Now let us understand what is the government's defense in this particular context. First of all, the central government has responded to the criticisms of the law, stating that the privacy and data protection related concerns will be addressed in the rules formulated under the legislation and through model prison manuals that the states can refer to. Also, the government assured that the rules for implementation of the proposed law would have safeguards against any misuse of the identification database and biological samples by fixing accountability of those entrusted with the safety of the data. Also, responding to the charges that the law is intrusive and violative of Supreme Court verdict on privacy, it said that only designated people will have court to access the data. Further on, those detained for the apprehension of breach of peace and in connection with political protest would be kept out of the law's purview. It also clarified that its provision do not allow narco analysis, brain mapping, or polygraph as part of the measurements. So this was a little bit about the topic. Now let us take up one practice question on the same. With reference to the Criminal Procedure Identification Act 2022, consider the following statements. First, it authorizes law enforcement agencies to collect, store and analyze physical and biological samples of convicts and other persons for the purpose of investigation in criminal matters. Second, the NCRB, that is the National Crime Records Bureau, is to be the repository of physical and biological samples. Third, the data collected will be retained in digital or electronic form for 75 years. Which of the given above statements are correct? You can take a moment and write your answers in the comment section below. So as we know, all the three statements are correct with respect to the Criminal Procedure Identification Act 2022. Hence, the correct answer is option D, that is 1, 2 and 3. And with this, we call it a wrap of today's edition of Topic of the Day. I hope you liked the video. I will see you with some other topic tomorrow. Till then, take care and do stay tuned.